We are. Good morning. It's Wednesday morning, February 12th, 9:15 here in House Transportation. Starting a little earlier than the agenda was originally for. We have special guests from Ledge Council and from our colleagues in the Judiciary Committee. So welcome, and I will turn it right over so we can move quickly through H44 and see what our impact and our piece on the committee might be related to this bill, which we did hear some about last session, I believe.
Maybe.
Fire away.
Great. Well, thank you, Mr. Chair. For the record, my name is Ben Novogrodsky. I'm from the Office of Legislative Counsel and the member of the office that is staffing this bill, H44, which is entitled An Act Relating to Miscellaneous Amendments to the Laws Governing Impaired Driving. So as the title indicates, this kind of touches on a lot of different laws that affect Title 23, the transportation title. However, these changes range from really technical corrections to update language to gender neutral language, some other things of that nature. It also closes some loopholes to ensure that the DMV is notified of license suspensions issued by the court. And then it also creates some accountability for non-compliance with warrant-based blood draws and other other consequences related to DUI crashes, in particular, ones that involve serious bodily injury and death. So that's kind of the general overview of the bill, and I can get into the details unless there are any initial questions.
No, it was that issue of the notification from the courts to the DMV that we heard about in Connect last year.
And I like to give this personal anecdote. So in my former life, where I was in private practice, I did some DUI defense to help my friends that I grew up with, and we would always advise my clients that your license is going to be suspended if a certain process has occurred. But secretly, there'd be a little bit of an inner monologue, being like, DMV may not actually find out about the court decisions. And so this bill attempts to address that issue where the commissioner isn't always being sent orders that affect driving privileges or things to that effect. So that's a little context for this. So starting in section 1, this I would essentially file under the technical correction umbrella. So you'll see here beginning in subdivision A8 of Title 4 of VSA section 33. So Title 4 is the judiciary title. This is about the family court jurisdiction. You'll see on line 13 that the word juvenile is struck, and then on line 14 that the addition of 52A of Title 33 is added. So the reason for that is juvenile isn't exactly a legally precise term at this point in our statutes. Typically, when you're talking about family court and those that are very complicated age range, but basically those that could be considered youthful offenders or juvenile delinquents. So really these are called delinquency or youthful offender cases. So we're striking juvenile, we're including the reference to 52A, which is the youthful offender chapter within Title 33, just to ensure that everything really reflects the reality that's in family court right now. So that's the explanation for those sections. So if you move on to page 2, subsection B, again, some more technical corrections, full name of the family division, striking misdemeanor because sometimes there are felonies associated with DUIs. Typically only when you get to the third or fourth one, or if there's a serious bodily injury or death resulting from a DUI crash. So that's why misdemeanor is struck on line 2. We're striking the time reference in lines 3 and 4, really just because it's not applicable at this point when this portion was passed. Typically there's some lead time, which was 2016 at the time. You don't need that anymore since we're in 2025. And then the addition of the reference to 33 VSA 5281, that's again a youthful offender reference, really in the determination of someone as a youthful offender. So again, just making sure that we're kind of crossing our T's, dotting our I's as far as the procedure and jurisdiction of the family court to hear youthful DUI cases. And again, you'll see on page 5, the reference to adjudication. That's because there aren't convictions in family court. They are adjudications, so this covers both situations. And then you'll see here on the addition of 7 and 8, anytime conviction is referenced in this portion, this definition includes adjudication. So again, just kind of closing the loop on that to ensure that decisions of the family court are reported because they're not necessarily convictions. They are just adjudications. So decisions, if you will, that the court issues to make sure all decisions that are relevant go to the DMV as well. So a lot of sort of legalese and judiciary work there, but any questions about sort of the jurisdictional changes in section 1?
Representative Ware?
So in terms of what was happening and how this bill is changing things, so convictions in the family court were not typically sent to the DMV or only sometimes?
So they're not considered convictions.
Okay.
And so what this does is add adjudication, which can cover any decision issued in the family court to make sure that those go to the DMV as well.
Okay.
Moving on, if there are no more questions, section 2 is really the meat of the bill. This really amends subchapter 13 of chapter 13, which is the drunken driving subchapter in Title 23. And you'll see at the outset, the addition in the definition section of Title 23, the addition of serious bodily injury having the same meaning as its reference in Title 13, but also that reference there is mentioned in other parts of this portion of the law. So in section 1210, the penalty section, so it's a little bit of a cleanup where we're striking those references in those particular statutes, moving into the definition to make sure it just applies throughout. So it's not really changing anything substantively, just more stylistic and organizational.
Yeah, so we see this a lot where it's like just cleaning it up and sort of getting the definitions right and okay.
Yeah. So
That's what this is.
exactly. This is a technical correction, if you will. Getting into section 1201 of Title 23. So this is the statute that outlines what constitutes a DUI violation. There are 4 bases to be cited for a DUI. When you have a blood alcohol content of 0.8 or more, 0.02 or more if you're operating a school bus, 0.04 or more if you have a CDL, or when the person is under the influence of alcohol, and I'll talk about that briefly, or when the person is under the influence of any other drug or under the combined influence of drug and alcohol. So those are the bases for which a law enforcement officer can cite you for driving under the influence. And you might ask yourself, well, what's the difference between under the influence of alcohol in subdivision 2 and any of the other ones? So this is sort of a relic, if you will, but still applicable of the time when we didn't have chemical devices to read blood alcohol content. So there's a case from 1933 that talks about under the influence being the slightest impairment. So it's possible, and it's a common misconception in our state, that's possible that you can be charged with a DUI if you blow a 0.01, not a 0.08. Typically that doesn't happen, but it's possible. But most people think like 0.08 is the magic number. Well, it is sort of. So just to give you a concept of sort of where these violations stem from, what they can be issued for, and then I'll get into some of the changes here. You'll see on line 20, again, this is one of those gender neutral updates from his or her to just the persons, and you'll see these throughout. So I might highlight a few of them, but I'm not going to spend a whole lot of time. You'll see here again, most of it, but you'll see the small change here on line 21, that a person may not be convicted of more than one violation of subsection A, and now adding or J of the subsection of the section arising out of the same incident. So what does that mean? So subsection A is what we just talked about. So if you could maybe be cited for being under the influence and a 0.08, but you can only be convicted of one of those if it arises from the same incident. If you have multiple incidents where you've been cited, it doesn't apply. And so what we're doing here, we're adding the addition of subsection J, and I'll set that up for a little bit. So subsection J, you'll see here, one of the things that occur in our sort of DUI process, right, is that you're pulled over. Officer has reasonable suspicion that you are under the influence of alcohol. Typically, he'll do the roadside sobriety tests. You'll maybe be asked to do a PBT, which is one of those sort of handheld blowers. You actually don't have to take that. But what you are under the obligation to take is the evidentiary breath test, which is typically back at the police station. What happens though, in the context where if that breath test equipment at the station isn't available, if someone is unable to provide a breath sample, so maybe they appear to be so inebriated that they can't physically do it, or if they're under suspicion of a drug, they can have a blood draw to assess their level of inebriation. And what that, however, and you'll see later on in 1202F, there's a warrant requirement. So while someone has given implied consent by just possessing our license and using our roads, there's sort of this bargain with the state that by doing that, you have implicitly agreed to submit to evidentiary tests if you're under the suspicion of alcohol, of being impaired. However, since a blood draw is more intrusive than just giving a sample of your blood, you have to get a warrant requirement. You're required to obtain a warrant. And that's a constitutional consideration under sort of the Fourth Amendment of the federal Constitution and then Article 11 of the Vermont Constitution, which is our search and seizure provision, which is akin to Article 4, but is more expansive. So what this does is that the addition of subsection J addresses the situation where someone does not comply with that warrant to obtain a blood sample. And this is proposed sort of an odd situation for both law enforcement and really for the suspect. So what this does is that in order to really, it puts the officer between a rock and a hard place. And so the only recourse to kind of provide accountability is to file an obstruction of justice charge. However, the difference with obstruction of justice is that unlike the majority of misdemeanor of DUI penalties, it's a felony. And most DUIs are misdemeanors. So it's an enhanced crime. And then also it doesn't have the rehabilitative aspects that a DUI conviction carries with it. So for instance, if you're convicted of a DUI or if you agree to a plea for a DUI, you have to your license is typically suspended. You have to engage in the IDRP program, which is essentially a rehabilitative alcohol treatment issue, if you will. They do a screening. Based on that screening, they assess your risk level, and then they'll make recommendations to either seek further counseling or other sort of rehabilitative aspects. And that's all if you are in sort of that DUI lane. But if you refuse to comply with a valid warrant that requests or mandates a blood test, and you're charged with obstruction of justice, you don't get any of that. So there's sort of a disconnect between the nature of the underlying crime and the state's chosen policy to help rehabilitate people and the recourse for not being able to conduct the investigation for public safety reasons and others. So what Jay is trying to do is to bridge that gap. And what Jay does is that someone that's suspected of violating the DUI laws shall not refuse to submit to the collection of an evidentiary blood sample when a warrant for that person's blood has been issued pursuant to 1202F1. And that outlines the implied consent for a blood draw and the warrant requirement. And the subsection does not affect the person's right to challenge the validity of that warrant. So that's a separate process that you can engage in through litigation in the criminal court process. So by saying that there's a requirement here to comply, you can still attack the warrant itself, but in the moment you need to comply. Because what this has done is created, there's also this concept of criminal refusal. So related to that implied consent bargain that the state has sort of had with us as drivers, there's the so implied consent, and then it gets into, sorry, I just lost my train of thought. I'm so sorry. There's the blood test. And so you'll see here, those three bases to obtain a blood sample. And then I'm going to reorient myself if you just bear with me a moment. Okay, here we go. Criminal refusal. So criminal refusal is when you've refused the evidentiary test. Now, there are only certain situations where you can be charged with a criminal refusal. Typically, it's if you've already been charged with a DUI previously and you refuse to take the evidentiary test, you can do that. And you can refuse it, but you can then be separately charged for this criminal refusal. So what this does here is it adds the refusal of the warrant permitted blood sample as a basis to charge someone with a criminal refusal. So again, it keeps it within that DUI umbrella, but we've now created a process rather than kind of going outside to hold people to account and with penalties that are sort of outside of the realm of what the legislature has decided. It brings it back here. And so you can still be charged with a criminal refusal if the process is required. You would, and there's still those attendant sort of rehabilitative aspects if you go through, if you are convicted of that refusal, and then the penalties associated with it, which are akin to the underlying DUI penalties. So I know I just threw a lot at you. I also didn't confuse myself, but lost my train of thought. So I'm happy to answer questions.
Just to clarify, so was it criminal
Refusal
is a misdemeanor?
Yes.
Then okay.
Yeah.
Yeah, I'm just trying to digest it, so I'm just trying to.
Find the really scrubs.
Yeah, no, if, so you can refuse now
Mhm.
and it's still a misdemeanor, it doesn't rise to the level of felony. And then we're throwing in the blood aspect of it, right? And that is only required in certain circumstances, like death resulting in somebody's inability to perform the
Correct.
test. Like either, well, if they're passed out, then I don't know how they would even challenge
Right,
it.
so that would be one of the bases that you could request a warrant to take their blood draw.
And the person doesn't need to be to consent or whatever, they can just be passed out and just. take it.
It's so in the statute, it's presumed that in that situation, they
Yeah.
have presumed to give consent.
Yeah,
However, there's another thing that this bill doesn't address, that a doctor or a nurse may not agree to do that if the
Yeah.
person is. So that's another sort of practical reality that this bill doesn't address. It really addresses the legal process, if you will.
yeah, so I'm just trying to think, you go, somebody goes in there, gets arrested DUI and they're just hammered and they don't have the breath capacity to continue to blow for a minute or whatever you need to blow. They're saying, all right, screw this, we need to take your blood. So you could refuse on this end and not rise to the level of a felony. But the blood part would, I'm just trying to understand how.
Right, so the way it goes is that right now, there's no way to sort of enforce the warrant.
Yeah,
So to go from those situations where they couldn't give a breath test to the blood sample, law enforcement officer would reach out to the judge, explain what's going on, judge issues a warrant, right? Once that happens, then they can proceed with the blood draw. But if the person comes to and doesn't and says, no, I'm not going to do it, and they refuse to comply with the warrant requirement, there's really no recourse for law enforcement at that point. And their job, they're under the obligation at that point to investigate. And now they are hindered in their investigation.
yeah, I understand that, but what I'm saying is that does that sort of, not to defend everybody that are drunk. One can always refuse now, right? And it doesn't
Right.
go to a felony. So
Well,
an officer also said, well, I'm just
it
gonna get a
could.
warrant anyways.
So right now, what this does is to try and create an avenue where it doesn't go to a felony.
Yeah,
Because right now, the only recourse for the law enforcement officer is to talk to the prosecutor and potentially charge obstruction of justice, which is a felony.
Yeah, no.
So that's the current
Yeah,
situation.
as you're a lawyer, you probably say, don't blow, don't blow, don't blow. And you go in there and say, I'm not blowing. And the officer says, well, I'm gonna get a warrant. And now that just raised to a felony.
Well, no, the warrant itself doesn't raise it to a felony. It's just the recourse if they refuse to comply with
That's
the
what I'm
warrant.
saying. I'm not taking it. Get your warrant.
Right. So right now,
Yeah.
their only recourse is to charge them with obstruction of justice or
Yeah, yeah.
hindering the investigation, which are both felonies. What this is doing
Yeah.
is trying to create it, keep it within the misdemeanor realm and the DUI
I
realm.
just must understand it. It sounds like you're raising it to, like if somebody refuses, it's automatically going to a felony.
I think the question
Yeah.
is,
Yeah.
if this passes, and you are asked to give a blood draw, and you say, I'm not doing it, even though you have a warrant,
Right.
what happens then?
That's what would occur is that then the only recourse for the officer
Charged with-
is to charge them with obstruction of justice. Because right now,
Today,
yeah,
but after this is passed,
they would
then
give them
be
the
charged with,
criminal refusal.
right?
Right, which is a misdemeanor and within that DUI umbrella. Because right now that exists for refusing the evidentiary breath test. So this bill attempts to create an equivalent for the refusal to take a blood test. Because right now that doesn't exist.
Representative White?
Just to clarify, because and Ian spoke about this yesterday a little bit, but my understanding is that the major change here is that if someone refuses a blood test, it currently today could be charged as a felony, and with the change, it will be charged as a misdemeanor.
Correct.
Had it backwards.
Thank you.
Sorry for the confusion.
That's great.
And that distinction, that change allows somebody to still have access to treatment, which they would be cutting themselves off from if it was elevated to the felony charge.
Yes, it'd be more likely that they obtain treatment, yes.
Okay, good,
Yeah.
yeah.
How close are we to hitting all of the transportation related issues in our?
We're getting there.
Really off of.
Okay. So I just want people, but I
We're
can,
not hitting our part of this. We're
sorry, I can speed
learning
it
a whole
up.
lot about the bill, but we are interested in the impact to the DMV, impact to transportation related,
So
not to settle the judiciary's portion of it.
Right. So to speed up on that again, so another technical correction, the civil suspension side. So this is not the criminal process, but the process to suspend your license. Just updating a slight gap in the law because it's 0.08 or above in the criminal process. Right now, it just said it had to be above 0.08 in the civil process. So you'll see here the addition of at or above throughout 1205 to align the two statutes. And then you'll see, so that's all in 1205. I'll get to the reporting requirements though, which are farther down. You'll see here, this is that cross-reference that I talked about, just striking, it's been struck from these statutes and moved up there, but this is more of a judiciary related issue. And then you'll see here in section 3, amends title 33 VSA 5202. This is one of the reporting requirements that basically changes it from an order of delinquency, since it's not always an order of delinquency that's issued in these decisions. So it's a merits adjudication would be reported to the Commissioner of Motor Vehicles. So again, kind of closing that loop that I mentioned before, it's also present here with regard to other orders that are issued, which should go to the Commissioner of Motor Vehicles as well. And then you'll see here the merits adjudication shall send a record of the adjudication to the Commissioner within 10 days of its issuance. So those are those loopholes that are within the transportation realm. And then you'll see section 5 creates a task force basically for, and this is a judiciary thing. You're getting a bunch of people that are involved in this to come together to talk about ways to shorten durations of law enforcement stops and also to reduce the paperwork and processing requirements that law enforcement officers have to file as well. So that's the goal of section 5. And then the bill would go into effect on July 1st. I really kicked it in gear there.
Flywheel, slow.
Yeah.
Oh, Representative Pat.
So was there just a percentage of cases that went to juvenile court that never, that were never reported to the DMV and people thought they were losing their license but never got any paperwork and just.
I can just say anecdotally that was happening, but I couldn't provide you any specific data to support that.
The 10 days
Mhm.
to report it, who is that? Is that set by, is that more of a court concern or a DMV concern? Is that that timeframe?
That mirrors language that exists, sort of for other similar provisions. So it's a reasonable time, but quick enough to,
From driving.
right. And for people to kind of make plans as well for their licenses to be suspended.
Oh.
Yeah.
Thank you. Anybody have anything else? I don't think that we need a strong poll per se, and that, I guess I'll look to Tim on that to a certain degree, but we just saying unless there's a barring any significant objection, we appreciate the chair of judiciary sending it our way and make sure. And based on what we heard last session, we're glad it's one piece of loophole that's tied up from.
I do know, when I walked through this with GovOps, they were talking about doing a straw poll. So I think that's up to the prerogative of the chair. So I just want to make sure that if Chair Lalonde asks, what I should say.
That our committee is on board with the changes.
Okay, great.
And thank you for the opportunity to review.
Yeah.
That's what I would say.
Okay, I'll say that. And I appreciate your patience, as I got into some more heady judiciary issues that I probably shouldn't have, but,
Well, everybody's interested in that.
yeah. I do it at my own peril, right?
And your testimony is always compelling. Your style is always draws the audience.
Oh,
Thank you. Thank you very much. All you also, then all that means we're not taking a break from, we didn't know if we'd take 15 minutes or 30. And so we'll move into our next piece. I think our next witness has arrived.
Sorry for taking away your break.
That's all right.
Yeah, nice to meet you all and see you again.
Yeah. All right. We have a minute or wait a minute, or we just start. Be a minute early, I guess. That's quite all right. I would throw out for the committee that multiple items on the agenda today and the rest of the week came out of committee discussion and requests for witnesses and requests for other spots. So I would certainly like to make sure that everybody understands, although we can't do everything that people ask for, we try to be as responsive as we can to bring in pieces that people ask for. So many of the pieces on the agenda for this week came from the feedback and the pieces that people asked for. Yes, Representative.
Do we have Roland from ACCD on the list who's in charge of the multi-unit, the charging for multi-unit dwellings in places and
We have I'm sorry?
she's
So
on?
Bronwyn, no, I don't know.
No.
Yeah, I would like to request hearing from her.
Advanced,
She's got a lot of statistics on the success of that program.
you're talking about EVs at this point, not advanced clean cars. I'm sorry, just.
No, it's
Oh.
about EVs. It's about the chart, it's about, yeah,
Yeah, multi.
it's about EVSE deployment through the Agency of Commerce and Community Development.
Right, on the charging portion of it, whereas right now we're moving into
Yeah,
advanced clean
I'm
cars
just
portion.
putting
Yes,
in a request.
okay.
Yeah.
Or whenever you're
Because
ready for that type of testimony.
we have money that we allocated last year from EV registrations that are going to that program. I think we're just looking. for-
Yeah, I mean, people who
How
are
the
paying
program is.
the double fee want to know where their money's
Right, and
going.
also
Okay.
how it's going and, what the demand is. The demand.
So we're moving on to our 9:45 and our witness is here and with us and one of the many requested topics and spots. So we'll give you a second to settle in and welcome this morning. And we appreciate your quick response to come back in and to come in quickly and answer some of the questions and pieces that we had in follow to where we were last week.
All right, I'm just gonna connect to Zoom here real quick.
Pam, did you send me the Zoom link in an email? Sorry.
Yes, it should be in
Okay.
the chain, but I can resend it.
We had a lot of emailing, so I'm trying to find it.
I'll
Sorry.
resend it right now.
Woke up to a very unexpected car problem. So text me.
Oh, I found it. Sorry.
Wow.
It took me a minute.
Hey. He didn't just. Not that he can't. I did text this one and say that. I got it.
Can you allow me to share my
Yes,
screen?
you're co-host now, so if you look
Got
at
it.
the bottom of your screen, there should be a box that says
Yeah.
share. That should allow you.
Perfect. Thank you.
There we go.
Okay. All right. I guess I won't be able to see my notes, but that's okay. All right. My name is Megan O'Toole. I am a senior policy advisor at the Northeast States for Coordinated Area Use Management. And I know a lot of you from a previous role I had with the Agency of Natural Resources. So it's nice to be back in front of this committee speaking about this topic. I'm also a Vermonter and an EV driver, so really glad to be able to talk with you about this topic today. So just briefly, for those of you who aren't familiar with NESCOM, we are a nonprofit that's made up of the state air quality agencies across New England and New York and New Jersey. So our board of directors are the air agency directors in each of those states. We're not an advocacy group, but we provide scientific, technical, and policy support to the state agencies that we support. So we collaborate with not only our member states, but also other states that have adopted these regulatory programs, federal agencies, industry partners, and other stakeholders having to do with low and zero emission vehicle policy. We lead several multi-state initiatives based on the kind of collection of states, and I'll go into this in a bit more detail in a moment, called the Section 177 states. We lead a mobile sources committee that's made up of air quality practitioners from those states. And then we also lead a multi-state zero emission vehicle task force, which is made up of not just air programs, but the other state agency practitioners that are vital to implementation of these programs. And we've also facilitated two significant memorandums of understanding, one in 2013 related to light duty zero emission vehicles, to which Vermont is a signatory, and then another in 2020 for medium and heavy duty zero emission vehicles, and Vermont is also a signatory of that MOU. So I just want to review some really key legal provisions that set the stage for why states are allowed to adopt these programs. The Clean Air Act has two key provisions that I'm going to review. The first is Section 209, which actually preempts states from setting their own emission standards for motor vehicles. The Clean Air Act mostly sets up a structure where EPA sets a floor and then states can be more stringent if they want to. That's not the case for motor vehicles. EPA sets a standard for motor vehicle emission standards for a variety of pollutants, including GHGs, greenhouse gases, but they do provide a carve out further in Section 209 that allows the state of California specifically to set more stringent motor vehicle emission standards than EPA. When California does this, they have to ask EPA for a waiver of the preemption that's included in the Clean Air Act. And California has to meet a series of criteria that exist in the Clean Air Act in order to be granted this waiver. And California has received a series of these waivers over the years, including for Advanced Clean Cars 2 and Advanced Clean Trucks, which I know you've heard about. And then further, Section 177 in the Clean Air Act says that if a state wants to similarly adopt more stringent standards, then they can only follow California, because the Clean Air Act and the lawmakers at the time didn't want to create what we call the third vehicle or multiple vehicles that automakers would have to meet, these different hosts of standards. There's really two vehicles in the United States that automakers have to make to comply with these regulatory programs. There's the EPA vehicle, and then there's the California vehicle, which also is known as the 50-state vehicle because it can be sold anywhere.
I'm sorry, I wasn't sure if you wanted to take questions during the middle or wait till
Absolutely.
the end, because Representative Howard
Yes, go ahead.
in his long tradition.
And maybe I knew this, why was California, by itself? Because of the size, because of air pollution at the time of the Clean Air Act? What was the reason that California got special?
All of the above. California historically has had more severe air quality issues, and in particular issues mitigating those problems. And at the time that the Clean Air Act was signed into law under the Nixon administration, California had already taken steps as a state to regulate air contaminants from motor vehicles in particular. And so the law recognized that they were kind of already ahead of the federal government at that point in time. And so they allowed them this carve out from preemption. And then in subsequent amendments to the federal law, Congress said, well, other states can do it too, as long as you're identical to California.
Thank you.
Sure. So who are the Section 177 states? There's actually quite a few of them at this point. This map shows the number of states that have adopted a California regulatory program, and the different shading signifies how many of those programs they've adopted. So you'll see that Vermont has adopted quite a number of California's regulatory programs for on-road vehicles. And what's also significant is the market share that these states make up. So for light duty vehicles, this represents just over 40% of new vehicle registrations. And then for heavy duty vehicles, just over a quarter.
Can you talk about how the states adopt the California laws? I mean, it doesn't go
Sure.
through legislation, right? It goes.
Correct. Each state uses their administrative process that's prescribed in state law for adopting regulatory programs. And obviously in Vermont, there is a level of legislative review that happens with rulemaking. So it's different for each state depending on what their law prescribes. So they adopt the rule, and then if California already has a waiver of preemption granted by EPA, then they're then allowed to enforce those rules. If there is no waiver of preemption, the rule can be on the books, but a state would not be able to enforce it legally.
Okay, so it's basically yellow card here for the state of that. Type.
Yes.
Yeah.
So I think it's always important to ground the current conversation about these regulatory programs in the history of these programs. And I'm sorry for all the acronyms. So LEV stands for Low Emission Vehicle, which is California's program to mitigate criteria pollutant emissions for motor vehicles. So we're talking about nitrogen oxides, carbon monoxide, particulate matter, things like that. And then there is a greenhouse gas regulatory standard, and then a zero emission vehicle regulatory standard. So the LEV program was first adopted in the 80s. And as you can see from the stars here, Vermont has actually been adopting and implementing and enforcing these programs for several decades, and adopted the greenhouse gas standards when California initially did in the late 2000s. So this is really just building on a regulatory program that has been, at this point is a well-oiled machine in many states. Yes.
So in the beginning, emission controls were added. California said, hey, we want to get to these levels. Car companies added these emission controls. weren't those sold all across the US? Didn't that become like the default? Or were you getting a different vehicle if you went to Alabama than California?
It's changed over the years. I think what you might be remembering is under the Obama administration, California and EPA were able to create and adopt a unified program that they called the One National Program. That was Advanced Clean Cars One, which is currently in effect in Vermont and many other states. Unfortunately, when the Trump administration came into office, following the Obama administration, they revoked California's waiver for Advanced Clean Cars One and then relaxed the national standard. And so that kind of turned that whole plan up on its head. But there was a point in time when the EPA in California had agreed to adopt a single standard.
So my question would be, Ford is making new cars and some are going to California and some are going to other states. Are they different?
It depends. Every manufacturer has a different strategy. But so for example, the state of New Hampshire does not participate in these programs. But if you go and buy a new vehicle in New Hampshire, I would bet you that if you looked at the vehicle emissions label under the hood, it would say that it's a California certified vehicle, just because you can't register that car in a state other than New Hampshire legally. And so, they're delivering vehicles based on what they know their consumers need and want based on where they're driving.
So
Yep.
It is possible you could get a different car somewhere else. That you
Yes.
could register in California.
Absolutely. There's many vehicles that exist that you would not be able to register in the state of Vermont because they don't comply with California emission standards, if Vermont has adopted those relevant regulations. And that's the way it's been for decades.
Does our Department of Motor Vehicles have the knowledge
Yes.
to recognize whether a
So-
car is allowed in Vermont or not?
I'm going to defer. I don't work for the state of Vermont anymore, so I'm going to defer to colleagues who I think you're speaking with later today from the Agency of Natural Resources, and they can talk about that in much more detail. Okay, so I want to dig into what zero emission vehicle sales requirements are, because I think that this is really the focus of your interest is this particular provision of the rules. So as I said, California and the Section 177 states adopt these requirements, and historically these have been meant to drive technology shifts across the industry, and they have done that. The ZEV requirement increases annually. And the ZEV requirement is specifically the number or the percentage of vehicles required in the regulation that need to be delivered for sale to each state. So I think that's really important. The point of compliance is the automaker delivering the vehicle for sale to the state that is participating in the program. So these are what we call supply side requirements. They're not demand side requirements, which would be like a fleet purchase requirement. For example, some of you might be familiar with the Advanced Clean Fleets rule that California has been pursuing recently. That's a demand side requirement. This is a supply side requirement. And the automakers are the entities that are regulated. There are no other entities that are regulated. Consumers are not subject to the rule. Dealers aren't subject to the rule. And I think that's also really important to state. And then, of course, states implement complementary policies to drive the demand side to kind of meet the supply that the OEMs or the automakers are delivering for sale into the state. So why would a state be interested in adopting these requirements? There's a whole host of reasons. Primarily, the reason under the Clean Air Act and historically is to improve air quality. Many states, suffer with air quality mitigation. And as you all know, mobile sources, the transportation sector is a really significant contributor to those issues. The adoption of electric vehicles also helps to address, historically disproportionately impacted communities that live near transit corridors that, suffer from health and other impacts. Obviously, to mitigate climate change, given that transportation is the largest source of GHGs in the United States and in Vermont. To provide regulatory certainty. This creates a regulatory floor for automakers to meet and allows them to plan and design their fleets in a way that complies with the rule. Generate economic growth. We've seen that transitioning to zero emission vehicle attracts public and private investments and creates jobs in jurisdictions that have adopted the rule. And then to enhance energy security and resilience. Electric vehicles are vastly more efficient than internal combustion engine technology. So it allows jurisdictions to rely more on local sources of energy generation and avoid the global market fluctuations that we see the fossil fuel industry being impacted by.
Can you explain what you mean by market certainty?
Regulatory certainty or
Create a regulatory floor and market certainty. So you're saying this regulation provides a certain way the market will act? What are you trying to say, that you're guaranteeing a market?
yes,
What are you?
that's
So
correct.
you're guaranteeing that the people will want, whoever the customer is, whomever, I guess is why, if you explain what you think that means, create a regulatory floor and a market certainty.
So I think the way you described it is correct, that it creates a market that includes electric vehicle technology as an alternative to internal combustion engine technology.
But not meaning that the market will necessarily buy them or not buy them. A
Well-
market meaning a group of people you advertise to or a group of people you sell to. You're
Sure.
guaranteeing sales. Is that what a certain sale, you're guaranteeing that the market will be there? I guess I'm not.
You're certainly
following
not
that.
guaranteeing a sale, but I mean, automakers are in a business, right? And so they need to produce vehicles that their consumers are going to want to buy. And if you look at the EV counts that are generated by the Agency of Natural Resources that shows the different makeup of electric vehicles that Vermonters are buying, you'll see that primarily they're buying F-150 Lightnings, and they're buying small to mid-size SUVs that have all-wheel drive capability. So if you're running a business and you know what people want and what they're going to buy, you're going to produce and deliver for sale that product to a jurisdiction. So that's the market that needs to be created. And if you look at Tesla's business model, they not only created a vehicle that people wanted to buy, but they engineered and implemented a vast charging network that gave people comfort in knowing that they could travel freely and charge whenever they needed to. And they've been wildly successful in that model. So I think the other OEMs could look to that as an example of how they need to create their own market to facilitate uptake of these vehicles in the jurisdictions as they're required.
I guess to follow that logic, you're saying that the Tesla example that was created because they decided they wanted to sell this many electric cars, we make a rule, then all the other OEMs can follow that and guarantee they'll have the same level of market. I guess what I'm saying is putting up a statement that says that the market certainty follows because of the regulation, I guess is hard for me to follow. Representative Wood?
Just to respond, the way I'm interpreting this information is.
You're welcome to question in that
Oh,
direction,
sorry,
but you're not
okay,
welcome to go
okay,
this
all right,
way.
yeah, okay. I'll pass that.
Thank you.
So I'm not sure if I
guess
answered
I'm
your
not understanding
question.
the definition of market certainty in terms of that the ZEV sales requirements guarantee market certainty. That's what I'm having a hard time understanding what that statement means. Please continue. Oh, yes, please.
Can I restate? Okay, the way I'm interpreting your information, and correct me if I'm wrong, is that regulations, for example, in Vermont, are guaranteeing automakers that there will be people to buy these new cars. And so if we're asking automakers to make changes in the kinds of cars they are delivering, it is a way to support the automakers to say, if you make these cars, there will be a market because we have regulations in Vermont that are requiring that a certain amount of these new cars that you're making will be purchased. Am I interpreting that correctly?
Well, I mean, there's many different, I think, forces at work in this program. As I mentioned before, states do, and Vermont is included in this, generate and implement policies that do create demand, like incentive programs, publicly funded charging stations, consumer outreach and education programs. So there's that component of it that drives the market. I think the OEMs themselves, in order to meet the requirements of the regulation, which the purpose of which is based in environmental and public health improvements and efficiency improvements, they need to create a compliance and business strategy that meets that requirement.
And I guess where I'm headed is what I'm trying to understand is if it's a supply side requirement, it doesn't guarantee market activity. It guarantees availability of product, but it doesn't guarantee what the Vermont law does not require. I'm pretty certain that you said it does not require anyone to buy a vehicle.
That's correct, but it does require the OEMs to supply the vehicles. And if they're in a business to sell those vehicles, then they can market and design and, facilitate purchase of those vehicles appropriately, which includes dealer training, includes all of the other complementary policies that are required to create a successful business strategy.
They have to advertise them, they have to produce them, they have to deliver them, but we are not providing certainty that they have to be bought.
That's correct.
That's what I'm trying to understand. Thank you very much.
Sure. Okay, so going back to air quality, as I mentioned before, vehicles are a significant source of criteria pollutant emissions, including most notably nitrogen oxides and particulate matter. And this graphic is just to show that this is US-based emissions, not Vermont specifically, but this is just to show that even though there are fewer heavy-duty vehicles on the road across the United States, they do have an outsized impact when it comes to their contribution to criteria pollutant emissions. And then same for greenhouse gas emissions, transportation sector is the largest contributor with on-road medium and heavy-duty vehicles and light-duty vehicles being the most significant contributor. And I also okay. I also just want to highlight that the air quality impacts, as I mentioned before, do disproportionately impact low-income and overburdened communities, and this just shows by census tract the level of exposure to the PM 2.5 pollutant, which has a host of really serious health impacts. So just want to really drive home that this is about environmental justice and making sure that communities that are most impacted by these pollutants see the mitigation from these pollutants.
Representative Keeler?
And these are national numbers?
Yes,
So these are not Vermont numbers?
that's correct.
Okay, thank you.
So I just really briefly want to state again, and I touched on this earlier, to ensure the success of implementing zero emission vehicle regulations, we're seeing states, including Vermont, take a whole of government approach. So the adopting agency that I understand you'll hear from later today is the Agency of Natural Resources, but across state government, they have several implementing partners, including the PUC, VTrans, the Department of Public Service, Agency of Commerce and Community Development, Agency of Ag and their Weights and Measures program, and then of course the Health Agency. All right, so I'm just going to get into some details about Advanced Clean Cars 2. This regulation is made up of 3 parts. It's not just the zero emission vehicle regulation. It also includes the criteria pollutant low emission vehicle standards for the combustion vehicle technology that is still being manufactured by the automakers. And then it also includes a really important component that we call the ZEV assurance measures that are also included in the regulation. These are things like warranty requirements for the vehicle itself and the battery components. and battery kind of charging requirements to make sure that consumers have a really seamless experience when it comes to being able to plug in their vehicle to charge. So we consider that a really important component to the standards themselves because it allows, as I said, consumers to really have a lot of certainty and comfort in understanding, how they can operate their vehicle and how the technology will function for the duration of the vehicle's useful life. These are the states across the US that have adopted Advanced Clean Cars 2. There is a span of model year implementation from model year 2026 to 2027. Vermont is implementing the rule in model year 2026. There's been a lot of conversation, I think, among the states and including in Vermont as well about how automakers comply with Advanced Clean Cars 2. And I think that this is a complex conversation. Compliance is a complex conversation because there are many different pathways to complying with the requirements of the regulation. I think you heard from some testimony last week about straight compliance, which is meeting the sales requirements that are the green line at the top of this chart. There's also several other pathways to compliance that the automakers are well positioned to take advantage of in the regulation. And these were put in place with the automakers as partners in negotiating the requirements of the rule and the different flexibilities that exist for automakers to comply. So as you can see, there's different levels of sales requirements that are kind of the realistic requirements if you take into account those different compliance pathways. There is an opportunity for automakers to earn environmental justice vehicle values. You can convert historic values from Advanced Clean Cars 1 to use towards future compliance. You can generate early compliance vehicle values under Advanced Clean Cars 2 itself. You can pool credits with other states to smooth out your compliance. And then you can also take advantage of a fuel cell vehicle value proportional credit, which is somewhat complex to explain in a short period of time, but this is to say that all of these different pathways allow an automaker to kind of choose their pathway to compliance. And I'll note that and I think you've heard this recently, that the percentage of EV sales in Vermont is already above what you're seeing as the floor here when you take into account all of these different pathways. I know this is a lot of lines and numbers, so if anyone has any questions, or happy to answer.
Representative Pouch?
Yeah, this is, there's a lot here and it's confusing. I'd be curious to walk through, an example of whether it's California or Vermont, what all these little steps. So we've been told, hey, there's 2 ways to comply.
That's not correct.
That you can either buy 30% or 35%, or the manufacturers will give you less gas powered vehicles so that the percentage on the lot is the 35%. So those are
There was 3, and then the tax.
Oh, then there was the manufacturers could
Buy credits.
buy credits, right? So those are the methods to meet it.
Yeah.
And you're telling us, there's actually a more complicated option.
There's even more beyond this, believe it or not. The option to buy credits from another manufacturer is not even factored into this chart that I've showed you. So we consider that type of option as a way for OEMs to kind of smooth out their compliance requirement at the end of the year. The rule also allows for you to make up any deficit that you have towards compliance over a 3 model year period. So you can kind of design your compliance strategy in a way that allows for you to make that up over a longer period of time, as opposed to being in compliance at the end of every model year. As I said earlier, you can bank credits towards future compliance. As I mentioned, many OEMs are already exceeding these requirements in Vermont, and so it's likely that they will have banked credits to contribute towards future compliance in the state of Vermont when Advanced Clean Cars 2 comes into effect. So there are many, many options, and I'll also note that all of these different pathways were designed with the automakers in mind. They were at the table having those conversations.
Just to clarify, all these options, are all up to the OEMs. There's nothing we're
Right.
doing, or, you know.
They design their compliance and their business strategy based on what the rule allows and the different pathways that are available to them. But I think that the option that has been discussed with this committee previously, we would refer to as straight compliance, which doesn't take into account any of what I've just discussed. And I think that the point of the rule is indeed for automakers to sell more of these vehicles. And so that is the end goal. And all of these different pathways lead to that. They can kind of choose their own adventure, basically. Okay. And I'm happy as you absorb this further and have more questions, I'm happy to talk offline if there's any further questions about these details. Oh, yes. Okay.
Yes.
Just one clarification on this chart here. So EJ vehicle values are environmental justice?
Yes.
Okay. And converted zero emission vehicles and plug-in vehicle values.
Those are credits that were earned under Advanced Clean Cars 1 that are converted towards compliance with Advanced Clean Cars 2.
So if those cars were sold in 2021, we
Correct.
can add those to our 2026 compliance regulations.
If an OEM is able to do that, yes.
Okay. Early compliance vehicles, fuel cell vehicle values. What does that mean?
The fuel cell vehicle values.
Yeah.
So that is probably one of the more complex flexibilities, but it does allow for OEMs to take advantage of any progress they've made towards delivering fuel cell vehicles for sale in California, and then kind of get like a free batch of credits based on their Vermont's sales proportional to California. So it's kind of a compliance cushion if you have started to explore deploying that technology in other states. You can take advantage of that towards compliance in other states.
Okay, and one more question on this chart. When I'm looking at 2026 and the ZEV stringency is 35%, everything below that is representing ways that we can earn up to 10%, earn up to 25% to get to that 35%.
So
Is that correct?
it's representing if you go all the way down to the 11% in 2026, the gray line, that represents an OEM taking advantage of all of the pathways that are listed. So that means that their sales requirement is essentially reduced to 11% in model year 2026. And as I mentioned, many OEMs are already selling more than that percentage in Vermont right now.
Okay, I'm just not seeing the 11% that you're referring to.
Oh, I'm sorry.
6.
Yeah.
It's a grade right here, right above 20.
Okay, gotcha. Thank
So
you.
instead of
That's
the
looking
ash,
short. Okay.
Representative Burke is up next, I'm sorry.
It's Megan.
Yeah.
So basically it gives, we've been hearing that, look, it's 35%, there aren't going to be enough people who are going to want to buy these cars. The charging network is not there, et cetera, but it sounds like this is offering lots of different options for meeting that requirement.
That's correct.
Thank you.
Representative Powell?
I was just gonna say, when you look at the chart, you're kind of thinking you're adding up there, but 35% is the goal. And by applying these things, really, if you were to apply them all, we don't know if that's possible or whether they would do that. The potential would be to actually be down to 11% and still comply.
Correct. So just one more thing to note about Advanced Clean Cars 2 and the power of the collective Section 177 states market. This just shows over the last 4 quarters of sales for which we have data, the percentage of zero emission vehicle sales in Section 177 states versus non-Section 177 states. So as you can see, it does supply a greater number of zero emission vehicles to those states to give consumers more choice if they want to purchase an electric vehicle or a plug-in hybrid electric vehicle. And then I do have some slides about advanced clean trucks that I'm happy to go into. I know you've invited me to speak about advanced clean cars, and we may be out of time, but
I'm sorry.
I do have them in my slide deck, and I'm happy to answer any questions about them if there's interest.
Real quick.
Yeah, so just on the clean trucks,
Mhm.
are there sort of the same sort of, they're not gimmicks, same methodology to reach the percentage rather than just straight sales? There's other opportunities for manufacturers, OEMs to get to that goal without actually selling at that goal.
Yes, and I don't have the visual that I have for advanced clean cars too, but I did provide a list of all of those flexibilities in the slide deck. The one that I highlighted here is the most significant for Vermont because it is actually the only state in which this flexibility currently is applicable. This allows state or OEMs that sell fewer than 25 tractors. So tractors are the heavy Class 8 trucks. If you sell fewer than 25 tractors in a particular state, you can make up any deficit that you have in that vehicle category by using the lighter weight truck credits that you've generated. And I think this is important for you all in particular, given that the sales in Vermont are at a volume where this particular flexibility would apply. So I think it was designed with you all in mind.
Thank you very much for coming in, especially with such short notice and on a topic that's getting more and more attention every day. So I appreciate it and thank you. And we're also moving on to our next witness, who was a response to a request from feedback and last week's testimony. We're going to transition from Megan. Thank you.
Thank you very much.
Welcome our next witness. The MPOs and planning commissions and peace came up in multiple parts of our budget review, and everybody wanted to know. Mr. Baker, thank you very much for coming in. Everybody want to know what you guys do and how come your money is addressed a little bit differently on a line in the budget, and what your kind of activities are and how it fits into our planning promotions throughout the state. So we'll give you a minute to jump in, but this came up 2 or 3 times in the budget review, and members wanted to hear more. So we appreciate you coming down so quickly and helping educate us.
Absolutely. Glad to be here. For the record, Charlie Baker, Executive Director of the Chittenden County Regional Planning Commission, and also with me is Eleni Churchill, Transportation Program Director on our staff. Just trying to make sure I can see what I'm looking at here. So what is an MPO? Why is it different? Thank you. So this actually comes out of federal law, out of the federal transportation law. And the roots of this go back to the 1960s when DOTs across the country were building the interstate highways, and some of them were blasting through urban, cities in ways that, I think those mayors and city councils were not pleased about. And so, they really went to the federal government and said, we need a voice in some of this transportation decision-making. And so the federal government listened and created MPOs in the 1960s. I can't remember exactly what year, and they are basically a requirement of the federal government in every urbanized area with over 50,000 people. So just, you probably don't look at these numbers on a daily basis, but just to give you a sense, in Vermont, in Chittenden County is the largest urban center. We have about 120,000 people in our urban area, which is 1,000 people per square mile. It's kind of a census definition. The second largest one is White River Junction, Lebanon area. That area has about 31,000 people, I think, in their urbanized area. I know Amy mentioned that briefly when she was here last week. So we crossed that border in 1980 census. We did not have over 50,000 urban in 1960, whatever. But so our MPO got created in 1983. It ensures federal spending on transportation occurs, and this is federal language law, comprehensive, cooperative, and continuing planning process is what we're required to do. There's more responsibilities that are in federal law, and they fund it. That's what you saw in Amy's budget presentation. Was there's a chunk of money that is by formula in federal law that flows through the state DOTs to MPOs. I'm sorry, I mentioned 1983. We initially started as just the urban towns in Chittenden County, which was 9 towns. And then in 1997, I think shortly after, later in the 80s, we started saying, well, because we're helping the urban towns, and we started a rural transportation planning with the other towns, the other 9 towns in Chittenden County. So it's kind of split 50-50. And then in 97, we said, let's just merge this all together. And that allows us to use the MPO funds even in our rural towns. And then another evolution happened in 2011. We had, prior to that, so for over about 20 years, we had an RPC board and staff and an MPO board and staff, and there's a complicated history there. At one point, one staff was serving both boards, then they divorced. They lived separately for a while. They got back together, started living together. Now got married, and now we're living happily ever after. So sorry, it was a real relationship. And honestly, when I took the job about 16 years ago, it was really somewhat dysfunctional because our boards were representing the same towns and not always agreeing on things, which was like, you represent the same constituents, you can't disagree. And so anyway, it works better now. We have one staff, one board that does both the MPO work and the RPC work. So what are the core federal requirements that kind of and so these are things that go beyond what VTrans requires the RPCs to do under the TPI program. And I'm sorry, I'm using acronyms. Please raise a hand. I think you guys are probably hearing those acronyms. We have a lot of them. That's how you know you're a professional. So the Metropolitan Transportation Plan, so we have to do a long-range transportation plan. It has to look out at least 20 years. We have to update it every 5 years. And for the other regions, they have a transportation element within their regional plan. So there's some analogy there. The Transportation Improvement Program is and this is really where the power, if there is power, comes from. It's kind of a negative power, but this is what the local governments asked for in the 1960s was our board has to sign off on any federal transportation dollars that VTrans wants to use on a project. So it's kind of a negative power in that way. We can't force VTrans to spend money on something they don't, and you don't want them to do. But our board could say, no, we don't want you to do that. And if you think about the history of it coming from the interstate, blowing through cities, it kind of makes some sense. There's a power to stop, but not a power to force.
Representative?
Have you used that power? I think of
I think the only, the one time I think there was conversation that was getting to that place was in the CERT days, going back, before my time, before the plug got pulled on that. But going back into the 80s or 90s, I think there was discussion. I think maybe there were even some of our municipalities may have voted against it, but not the full board. And the Transportation Improvement Program gets voted on by our board. We do we take all the information that you folks, when you vote on your capital transportation program, that we take that information and pull it into our Transportation Improvement Program and really work cooperatively with VTrans so that we are blessing the same list of projects so that the federal funds can keep flowing through to VTrans. I'll frame it in a much more positive way, right? So we kind of cooperate and work with VTrans to do that. And it says updated annually. Honestly, we're almost updating it monthly because of changes that are happening on specific projects as VTrans goes out to bid. We've been seeing a lot of projects that are, coming way over the estimates that we might have had in the capital program, particularly the last few years. It's been a pretty intense, and not news to anybody. Prices have gone up. Newsflash. The Unified Planning Work Program, that's a kind of unique label in the federal requirements. But we've taken to using, so this is a way that we document what we're going to work on. And these are planning funds. I think Amy covered that a little bit, but they're only transportation planning funds. We can't use it for engineering. We can't use it for construction. It's a significant amount of money, but we can't build a sidewalk with it. So how do we figure out what to do with the planning funds? We ask every November, we ask all of our communities and any other partner, and frankly, the community, if they have ideas for how we should use these funds. In January, those submissions come in, and we have a committee that reviews those requests. Sorry, I know Phil's nodding from his days on Heinsberg Select Board, and Kate with Shelburne, are familiar with the select boards sign off on what is being asked of us. And then we compile all that, review it. We've been pretty much able to fund and support every request we've gotten. And so we're in that process right now. We'll talk a little bit more about kind of the budget in a minute. The fourth federal requirement that we have that is different from the other RPCs is a public participation plan. So we have to have a formal document that communicates how to engage in our processes. So that I think we'll probably update that in the next year or two. So what kind of work are we doing? This is kind of going from maybe more technical to less, but scoping projects, I think you're maybe familiar with that term. VTrans uses the same term we're maybe not doing exactly the same scoping. Maybe it's a little bit scoping light, as Elaine would call it. And partly because our funds can't go as far as VTrans's funds. So we can't get it through NEPA. We can't get all the way through the engineering plans. So we can only do the planning work. But when we're doing scoping and project definition, we're really trying to work with the residents and the town to, here's alternatives, here's a recommended alternative, or maybe you got to make a decision between two alternatives. So it's a lot of conversation locally, a lot of public engagement. And then we can do quarter area-wide studies. Those are a little bit higher level up. Active transportation study work, bike ped, land use and transportation. We've been able to get approval from Federal Highway to say, well, this is helping us to have a more efficient transportation system if we work on zoning to create more density and walkable community stuff in our urban areas. That's been pretty popular. If you're familiar with Taft's Corner, we just did a big zoning update there with form-based code and a street grid network and sidewalks and stuff. And we used MPO funds to do that. That's just one example, but we've been doing a lot of zoning work. And also I think so that's housing work in a way, right? We've been kind of increasing zoning density to increase housing, which has been an issue in our region that we've been talking about for a while now. Also, other planning with transportation access, we've been able to leverage some of this funding into water quality. So road runoff from roads. We can do some stormwater work, look at culvert sizing and things like that. Energy, I know you're just listening to some EV stuff. We've done some EV charging planning, other things related to transportation-related energy issues, operational studies, speed studies, safety studies, looking at signal timing, signal warrant analysis, other technical assistance. And we do a lot of data collection. One of the other things we ask for towns is not just these planning projects, but also what data would help their public works or road crews. And so we do a lot of culvert inventories, sometimes it's sign inventories, any data collection, traffic counts that would be helpful to towns. Some of it's regional level. And then we also, sorry, I know this is a long list. Welcome to our work. But we also,
What the numbers wanted to know.
yeah, as the money has gone up, over the years, we've also been able to take a chunk of it and invest it in partners in our region. So GMT, I know you asked about that last week. We used to contribute about 400,000 a year, which is, I think, maybe the number that Amy mentioned. We're actually at closer to 650,000 now. We've been upping that number the last couple of years. CAPMA, which is I think they were in here recently, the Chittenden Area Transportation Management Association. They get over 100,000. Locomotion, Jonathan's here. We provide them over 100,000. Car Share Vermont, that's probably a lesser number, 60,000 or so. Transportation Research Center at UVM has some, maybe every other year recently been asking for funding for some research projects. So we've been trying to share as much as we can. Happy to take any questions along the way. And we work like the other RPCs. We're kind of like a public sector consulting agency. We don't have any general tax revenue. We don't have any other fundraising ability. 95% of our revenue does come from state, federal grants. 5% comes from municipal dues. And in our region, our dues are over $250,000, which is significantly higher investment from our towns and other regions. But we also need their dues to match these federal funds. And that was one of the other questions that came up. For our base work, so the work that supports staff and any regional projects, VTrans provides 10% of the match and our towns provide the other 10%. So we do appreciate that's a significant state investment for us in this, but it does leverage 90% more funds coming to Vermont. And the dues, this is maybe not too relevant, but just the way Chittenden County does it, we do it based on equalized grand list, the kind of each town's ability to pay. Williston pays a lot more than Heinsberg does.
But Phil, write a check.
He's written up, well, back in the day. Budget. So our overall budget, we just, every January, we update our budget. It's over 10 million now. Just a note, and I'll kind of say this a few times, it's overestimated. That's a very rosy scenario of the money that could go through us this fiscal year. Last fiscal year, we were, maybe a little bit less than that, 9 something. There were probably about $2 million of that, we have in our work program, but just between either the town or our human resources, just didn't happen. Things sometimes slow down, sometimes things need to be paused and come back to. So that's the overall budget. And you can see the vast majority is coming from our transportation funding. This number here of 7.3 million is different than what Amy showed you in the state budget. And that's because because of the municipal funds, the municipalities also kick in money if they have a particular study that they want, an intersection study or Main Street study, whatever it might be. They can also do the full 20% match on their own. So there are projects where the town is coming up with the full 20% match and it's not on the state. The state's not involved. So anyway, there's more money in our transportation budget than just what Amy showed you last week. And we also have a RAISE grant, which was a federal competitive grant we got a couple of years ago. I guess we'll go back to BUILD, which is what it was under the Trump administration, but it's about $1 million of this 7.3. Any questions on this? I'm ignoring the other topic areas there, but.
Are any of your federal funds in jeopardy right now, or you don't?
Well, I have a lot of faith in VTrans. And so, they've been the ones communicating with the feds and not necessarily on our behalf, but we're part of it. My understanding now, and VTrans can maybe give you a better answer, but is that because these funds are dictated by federal law, through that formula that Congress has approved. They're not at risk right now. The things that seem to be more at risk are where the Congress has given the administration, the federal administration, more discretion and discretionary grants.
Or like the raise grant.
So the raise grant is an open question.
Yeah.
And so the Federal Transit Administration decided to take charge of that grant. So we've kind of put that work on hold and are awaiting FTA, tell us one way or the other. Or are we still good? Can we get reimbursed when we invoice you or not? And we're still waiting for that answer.
Representative Powell?
Thank you, Charlie. Is it possible for you to just sort of do a very brief overview of what's different in the other regional planning commissions, because
the biggest thing is, they're getting $200-something thousand for transportation planning, right? Maybe I'll just start and end there. It's so much more money that comes through that federal formula. And we're also one of the only states that has one MPO. And so we don't have a way to share it. Well, sometimes we work out some ways to share it, but that's the fundamental difference. We do the TPI tasks. I don't know if you've gotten down to that level yet this session, but there's a number of tasks that VTrans asks all the RPCs to do. Some required, some optional. And we include all those tasks also in our work program. So we do that, but then we're doing a lot more, obviously. And then this is kind of the breakdown of that 7.3 million. You see that $1 million raise grant, the 6.3 of the money coming from Federal Highway and FPA. 450,000 going to the partners that I mentioned, like Locomotion. GMT, the 650,000, about 2.1 for our transportation planning staff. And then the vast majority is going to consultants. And so, most of our transportation planning work is done with consultants. And sometimes that might even be inventory work. Like we've been hiring consultants for transportation related stormwater work. We've been having a consultant who has a machine that goes through the stormwater pipes, and so that information can go to the town, and they can know where to fix pipes or where there might be clogs or whatever. Part of their water quality work they have to do, and so we've been able. Sorry, that's just one example. So it's been expensive work, but we're fortunate to be able to have the resources to be able to do that kind of thing. And that's just one example. So here's just a few examples of projects. Kind of starting with some big ones. A few years ago, we did a large-scale study of I-89 in Chittenden County. Looked at the full 37 miles and kind of like tried to look out for in the future. Any projects on the interstate are going to take a long time to get through permitting and engineering and NEPA. I know 2050 seems like a long ways away, sometimes for big transportation projects that far. One of the big things that we were looking at there is, and this is really kind of centered around exit 14. It's the busiest, most congested interchange in the state. And if, particularly as we're addressing the housing crisis, if we continue to grow, like what happens, we'll do it. And so we kind of looked at options, evaluating whether we might need another interchange or maybe exit 13. I'm sorry, but please let me know if anybody needs any more detail, but exit 13, which is the 189 spur, should that turn into a full interchange? We also looked at an interchange where 116 crosses 89. And what was the third one, Eleni? And exit 14. Yeah, and exit 14. So those were, we're kind of so very south. All those three ideas are all in South Burlington. We spent a lot of time with the South Burlington City Council and a lot of public meetings discussing these ideas. We did come up with some possibilities, but then also kind of paused. The interchange idea isn't really ripe yet, but in terms of a new interchange, and it'll be some time maybe. And what we did in the implementation plan was include some triggers of like, hey, when things get too bad on Route 2 and 89, we might need to come back and start working on another interchange. So trying to be flexible and not dictate. There's, we'll see how it plays out. And just to dive a little deeper into exit 14, which is someplace where we do think an improvement is going to be needed. And it may be timed when the structure needs to be replaced. Like, okay, if we got to replace the structure, then let's upgrade how that structure is connected. And so we looked at some different ideas here. And we're doing a kind of a supplemental scoping on this now to get into further detail. Did you want to add something?
No, I just want to say that, we're still in the evaluation of the alternatives at this point, so we are gonna have, public, like engagement as well as stakeholder engagement. And then we'll bring it to the South Burlington City Council for a preferred kind of alternative, locally preferred alternative, so we can present that to V-Trans, because V-Trans is gonna take it, scoping finishes, V-Trans starts with, when they identify funding, they start with VIPA. And, the training or engineering. That's kind of where, so scoping is the very beginning of the project development phase for every transportation project that has federal funding.
Another thing, we work a lot on transportation demand management, things like alternatives to driving. One thing that came out of the 89 study was, okay, that all sounds good in theory, but do people, really want to do it? What policy changes or whatever would actually help encourage that behavior and reduce congestion on our highways? And so we're right now focused, one of the other things we're working on came out of the 89 is a regional transportation options plan with a real focus on implementation, what actions need to happen to see results, what's the timeline cost, who's responsible. So that's something that we're working on right now. Winooski River Bridge, you may have heard about. We did the scoping on this several years ago. And this is kind of the cross section of it, much wider paths on the side, a little bit more shoulder. I don't know what the existing width is, like 60 feet.
Pretty narrow.
Yeah,
It's like,
it's maybe 50 something feet. So this is 81 feet. It's a significantly wider structure. This bridge got built in 1927 after the Great Flood. So, a few years ago, it was like, I guess we're getting pretty close to 100 years old. So it's going to be 100 years old. We also worked with V-Trans to apply for a RAISE grant for this project, $25 million of discretionary federal funds. There was talking about applying for another one of those grants because this cost is getting quite large. We'll see if the federal administration even has a grant program option, hopefully sometime in the coming weeks. Other things we worked on, looking at protected bike lanes with piloted projects, worked with South Burlington on their exit 14 bike and bed bridge. We did the scoping for that. And then they've applied for other grants to help implement. Here's more of a rural town in Richmond, Cochrane Road. We worked on how to improve make pet improvements and make it Cochrane Road safer for pets. There's a trail that crosses the road, so you can kind of see the existing and some ideas that might help improve the safety for those pedestrians. And then this is the final project I'm going to talk about, the RAISE grant. This is a place where we were able to kind of leverage our work into other neighboring regions. And so we got over $2 million. And kind of the pitch, this is a little bit land use, housing, transportation, what can we do to build more demand for the transit system to make the transit system work better? So we're really kind of focused more on the housing end, the demand side. Interesting to hear you talk about markets, right? It was just a market. And so we're really doing a lot of work with kind of master planning and zoning in 10 towns: Rutland, Middlebury, Virgins, Ferrisburg, Berlin, Berry City, Northfield, Essex Junction, Milton, and St. Albans. So this is a case where we can. I'm definitely interested in trying to take our funds that we can and invest in neighboring regions too, because it's really, our labor market shed, is pretty big, right? It's not just Chittenden County. People work in other counties or live in other counties and work in Chittenden County or vice versa. So we are working in all those towns right now. And that's all we got. But happy to give you any more details. Sorry to take a few extra minutes, but thank you for the time.
Because we definitely want to. We very much appreciate you coming in so quickly and giving the background of what everybody was asking and questions and pieces at. Please, Representative Witt.
Yeah, thank you for your presentation. So just a clarification on your last slide here, the Northwest Vermont
Yep.
TOD project. And maybe I wasn't listening, but so I'm curious, Northfield and Berry City and Berlin fall into your jurisdiction or?
No, just us trying to share funds when we can. So basically, because the way the DOT grant, had some criteria that was like kind of transit oriented, we asked towns that are on the rail lines who was interested in any of our neighboring counties. And those were the towns that were interested.
Representative Pat.
It's no secret to this committee that I really would like to get more money to municipalities to do infrastructure, resilient, climate resilient activities ahead of storms. So I think, Heinsberg and other towns in your area, have the ability to understand or size culverts and maybe come up with priorities. But in more rural areas that, don't have an MPO, how would those smaller towns, let's say, if they wanted to apply for, if it was a grant or it was a formula fund, how would they know, the 5 culverts, the one that's, not only deficient hydraulically, is, on the appropriate, it's a high demand area versus a, one house at the end of the street. So is that available through other planning?
As you said, so I'll say Chittenden County and actually, Lady and I have been talking recently, we're gonna try to do kind of a resiliency implementation effort in this coming fiscal year. But we're really building on, so here's I think if you're talking about outside Chittenden County.
Yes.
Because we have the funding to help support towns, we're digging into that deeper. And I think we'll come up with some, take what VTrans has been doing with the transportation resiliency planning tool, where they kind of identified kind of the highest, and I always forget the two things, the vulnerability and critical pieces of infrastructure, right? So they've done that beginning analysis. We're trying to take that down to the next level and get it down to prioritized projects, just like we were talking. For the rest of the state, I do think there's a need there and some help. And, I think the TRPT may kind of point the direction of where to focus some funds. But it is another layer of work that needs to happen to help them prioritize. And, I think we've been also talking with VEM because we work with them too, of like, can we get some hazard mitigation money? Because these are really, when the road blows out or the culvert blows out, the bridge, like that's also emergency management money comes to play, right? And so I'm hoping that there's some of that. I think a lot of those projects have been getting prioritized through the hazard mitigation program. So I don't know, you might want to have some conversation about how that, VTrans connects in with that. Yeah.
Thank you very much for coming in. I appreciate it so quickly.